Hi everyone, today we will be continuing with part 2 of the reserve judgment made by a judge on the 27th of February 2017 at the District Court. I will be reading the actual quotes from the actual judgment that was written. Just a note that this judgment was actually appealed against, but that's another topic on its own. But I will be going through the appeal, and I will be pausing at some of the portions of the paragraphs when I feel the need to actually explain in detail in regards to the actual paragraph that judge has written. Point 20. At the hearing, the plaintiff sought to rely upon a different statement of claim, being a statement of claim attached as anorexia through to the plaintiff's affidavit of the 25th of July 2016. So the judge is talking about the actual second statement of claim. The second statement of claim utilises the same court civil registry reference number as the original statement of claim. The defendants listed are the name of government agencies. So judge here is talking about and confirming about the actual second statement of claim that I was asked to change. But by law, if those who know the law or have an understanding of the law, according to the legislation, you can do parties individually, care of the company. And that's where I got, where I actually, broke down the actual defendant and defendants as individuals. But because they were working for the government agencies, because they weren't private, so I actually put the name of the actual government agencies that they work for. But in saying that, because they've broken up the system, even though everyone is in one massive umbrella, this new system has broken up different government agencies with different entity. But at the time I was doing this as a government agency as a whole. And the legislation actually allowed me to do this. So that was something I already knew, that I was on the right path right from the beginning. Unfortunately, there was a dispute about it and with the registrar at the time. And so just to, I wanted my case just to go forward. They charged me $75 just to have the names amended to the actual name of the agencies at their advice. So that's, it's not something I just made up. You can do either, according to the legislation at the time that I did this civil case. So you're going back to 2016. So with that, from that day forward, since I lodged the actual second statement of claim, I stuck with all my legal documents as the name of the government agencies instead of the first one where all the individuals were actually named individually. So whatever happened from that time and me corresponding with the registrar and the courts, the fault falls at their end, because I've done everything according to what I'm supposed to do. And I can prove all that in the legal system, but unfortunately my case was being sabotaged. And if you were watching the episode when I was talking about human trafficking by force, and I was talking about substitute and being cloned with one party, two party, that I was going through whilst I was working for my job. This is the same methods and same thing I was going through when I was going through this whole court case process. But that's also the reason why I took the initiative to serve all my legal documents myself. So anything that I was able to, like a traveling distance from where I was living, I served it myself personally at the door of whoever received it at the company. Except until the only time I couldn't do that was when I had to go through the Court of Appeal system and the Supreme Court system. So I had to do everything by postal. I didn't have a choice there. Point 21, the differences between the original statement and the second statement are the following. A, the specified defendants, the date each respective documents, 4th of July 2016 and 28th of July 2016. Note, the second amendment's notice of proceeding and state of claim were both addressed in the hearing on the 27th of February 2016. The councils claimed they weren't served these documents, and I proved to the judge that I had served them by showing her and the councils the sworn affidavit in court. So that was one of the issues that arose in that first hearing, on the actual first hearing, which was the 27th of February 2016. So keeping in mind that every court hearing by law, everything is recorded, so that when you ask for a transcript, all this sort of thing is supposed to come out in the recording as evidence of what actually happened at that actual hearing on that day, and there's reasons for that. So both notice of proceeding and statement of claim went through the court process, and it passed the court protocol rules and regulation according to the legislation through the deputy registrar. So for anything to even get to that level of where a hearing is, you've got to pass all the court's rules and regulations according to the district court rules, and the protocol and the status and the regulations of the system. So anything happens in between that, the fault lays at the court if there's any misunderstanding with the judge and the councils. But as far as I was concerned, I did my bit. The content is exactly the same in both documents. Yes, the content was exactly the same, but it was just the name of the parties that were the issues. So that was the only thing that was amended in the second one, was the names of the parties. Okay, the plaintiff confirmed she had not applied to include the names of the government agencies, and no other has been to that effect. The plaintiff stated she has sought legal advice but is unable to afford a lawyer. When pressed on the issue of the proposed additional defendants, she requested that present proceedings be transferred to the criminal jurisdiction. This is a request that was, and more than once, the plaintiff, to which I shall return to. There was another hearing on the 1st of November. So that was the first conference that I had. And I actually asked for it to be transferred at this hearing. There was a bit of a issue there with the judge and how it was handled, but I did make an oral application at this hearing to have it transferred to the criminal jurisdiction. And I actually took 2 witnesses with me who sat at the back and can verify that the judge actually did say what she said, that she said I could apply to have it transferred to the criminal, but I actually had to make it in a formal application, which I did. Note A, the request to have case transferred to the criminal jurisdiction was requested in an interlocutory application of objection for order to strike out dated 23rd of February. Yeah, it was dated 23rd of February 2017, and the defendant joint submissions dated 23rd of February 2017 was acknowledged. So that's judge's notes on the judgment. Now just talking a little bit about an interlocutory application, they're actually sworn affidavits, like they're actually sworn legal documentation. So whatever you swear legally, they're actually legit evidence. So you got to be very careful that what you do put an oath on, if it's not true, it will backfire. But this documentation was, I actually had it sworn. So it becomes an illegal documentation, and if I remember rightly, I actually submitted this too at some stage as an exhibit when it went further on with my case. Carrying on with the judge's notes. Submission. I invited the plaintiff to outline her grievance to me to assist in my evaluation of the statement of claim. It is to the fourth defendant assessment that was significant in the employer's decision to dismiss her from her employment and medical related grounds. The plaintiff submitted that the fourth defendant has ruined her life and reputation. She said she has never met the fourth defendant. Result of his assessment, she has suffered significant hardship. Defendant 1, 2, and 3 were medical personnel who had contact with the plaintiff during her detention at the mental health unit. The plaintiff challenges the lawfulness of the initial assessment and her detention. The plaintiff said the use of the mental health act against her was inhumane and has resulted in very serious consequences for her. The fifth and the sixth defendant are the doctors who carried out a historical mental health assessment back in 2009. When pressed as to the relevance and possible claim against these two doctors, the plaintiff stated their assessment inaccurately described the plaintiff as a victim of rape. The reason why this info is important is because it was a secret I never told anyone until I read what was on the report in 2009. So that's my own word, that last sentence I just read. The reason why this report really upset me, and then I submitted it in 2010 with the protected disclosure. It really upset me because it was a secret that I never told nobody. It's also my confirmation how private I am. So I was absolutely upset when I read this in the report, and there was everything on the report was fraudulent. They wrote their report as if I was in a domestic violence set of circumstance at that time, and I wasn't. I wasn't in any relationship. I was a single mum at this time. But what I read on the report, it just looked terrible. Immediately, all I saw was, that's just wrong what they wrote. But the fact that I put rape, I was raped, that really upset me because I never told those women. I can prove that. I didn't even tell the father of my children. Why would I tell two strangers I have never met in my life and whom I had an assessment with for like 30 to 45 minutes, and then I never saw them ever again? But I was very upset to read that. And I wanted to know, and that was the reason why I put it in a protected disclosure in 2010 with an affidavit. So it was a big deal to me because that whole report, everything they wrote in that actual report basically ruined my reputation. And it was also, just a reminder, while I remember, it was also the report that one of the doctors referred to when they used the actual act on me, and that was on the 5th of February 2017. So that's another reason why this report was brought into this time, because the doctor that met up with my family, and that was actually in a court case, she brought up this report, and this is what she went on, and this is where she got her information from. So that's why that report was, it now had become evidence to what I was going through. Okay, so I'll carry on with Judge's note. The plaintiff feels strongly that the Mental Health Act was used against her in an inhumane and unfair way. The plaintiff concluded her submission by starting, "I have already sought legal advice and it's definitely criminal." The plaintiff stated she would consent to the present proceedings being transferred to the criminal jurisdiction, but did not consent to them being struck out. "I advised the plaintiff that I had no power to transfer the proceedings from civil jurisdiction to the criminal jurisdiction. The plaintiff submitted that there is provision at law and undertook to provide me with the relevant statutory provision by 5 p.m. on the 28th of February 2016. So at this hearing, the councils actually made an application to have my claim strike out. But the judge didn't strike out because I didn't consent to it, and the judge can't make any direction at the advice of counsel because it was my claim and I didn't agree on it. I also, once again, I made an application to have it transferred to the criminal jurisdiction, and as you can read what judge said to me in the court. So I actually asked for an adjournment so I can get the lawyers together to support to support my submission to have the case transferred to the criminal jurisdiction. The judge gave me till 5 p.m. the next day to get all that information together. The next day I did what I said, and I gave it to, I went to the courts where the hearing was. The judge was actually a residential judge, and I knew she was waiting for my application and what I had submitted over the counter. At this time, I decided that I would submit the CD of the actual hearing on the 4th of February 2016 with the psychiatrist, one that was actually on the episode. So I submitted that as an exhibit to the judge, and the councils got all that on the same day. I did everything all in the same time. And I served them personally myself, and along with the CD that I submitted as an exhibit and an affidavit and the transcript, there's a transcript to it, and there was a sworn affidavit attentioning everything to the judge, along with the case legal lawyers that support my case to be transferred to the criminal jurisdiction. So all that was submitted. In fact, this information was challenged, was actually noted in the first appeal, and the name of the registrar who served me, who had, I could tell by her attitude that she had no intentions of making sure that the judge got these legal documents. I actually said to her that the judge was actually waiting for them, and she had asked for it to be, delivered to her before 5 p.m. and that she'd given me a deadline. But I could tell with her attitude, she had no intention of following through what I'd requested, and I saw her just throw it inside the inbox that they have when you get stuff over the counter. So, but this information was actually in the appeal. Anyway, I'll carry on. Point 32. On behalf of all the defendant, counsel relied upon the written joint submissions filed. The defendant submit the statement of claim should be strike out as it discloses no reasonable arguable cause of action and is otherwise an abuse of the process. Okay, point 33. The defendant submit the plaintiff's statement of claim is and discursive and does not specifically identify a cause of action or complaint. Rather, it relies to various medical personnel who have been involved in assessing the complaint's health and safety since 2009. Reliance is placed upon the reliant rules, which include the need for a statement of claim to evidence the nature of the claim and the relief, including sufficient detail to enforce the court and the parties of the cause of action. I will now consider the alleged claims against the various defendants. Fifth and sixth defendant, point 36. The plaintiff has not identified a cause of action. Any subsequent documents filed on her submission at the hearing, nor can I identify any direct relevance between the 2009 health assessment subsequently carried out by the remaining defendant in 2015 and 2016. The fourth defendant for the employer assessment in his report of 19th of November 2015, the assessment of the fifth and the sixth defendant is not listed. The plaintiff submitted the 2009 assessment and accurately describes her as a victim of rape. The 2009 assessment has not been included in the various documents the plaintiff has filed with the court. The 2005 assessment of the fifth and the sixth defendant is not listed. Pause there. Okay, when I submitted a notice of proceeding, there is another application that goes along with that, and it's called the plaintiff's list of documentations relied on. So these documents that I submitted with the actual civil case, you have to actually submit the legal, the documents that your claim is relied on. So I had it all listed, and I will read out what was actually in with the statement of claim. There was an affidavit and the mental health assessment report dated July 2009 that judge just talked about. She didn't get it. It definitely was in there, and in fact as time went on it became an exhibit. Report made by the fourth defendant dated 19th of November 2015. So there was a report in there that the doctor who wrote the report for the employer that was in there. Then there was a medical certificate from the family GP, and this medical certificate was vital evidence to prove the reason why my family GP had sent me to go to this mental health assessment on the 4th of February with the psychiatrist was to get my medical certificate renewed. That was a reason why I was told to go to this appointment, and so that medical certificate was in there as just so the judge can see why it was there, because it was actually on the actual statement of claim, but there was a paragraph there explaining the reason why I was actually going for this appointment at the mental health district board at the time. Also in there was another documentation, and this is called the, I called it the psychiatric interview dated 10th of February 2016 from the first defendant. So I actually asked the first defendant, because I knew he had recorded our assessment, you know, the mental health assessment. I knew he had recorded it. I asked him if he could give me a copy of the actual transcript of what was recorded. So he gave me a copy of it, but he had dated his transcript the 10th of February 2016. So he actually had the date wrong, because I wasn't even under the care of I wasn't there, because I was out by the 9th. But I had actually put that in there for the judge as a reference to that. These are the things that are the issues that I was addressing in my civil case. The plaintiff submitted the 2009 assessment and accurately describes her as a victim of rape. The 2009 assessment has not been included in the various documents the plaintiff has filed with the courts. The significance of that inaccuracy has not expanded upon. Point 38, it is clear from documents the plaintiff has chose to file that she has had a difficult personal background. The application to enter summary judgment includes the plaintiff's background. In that section, the plaintiff has included details about a marriage that involved family violence, prior assistance from Women's Refuge, and obtaining a final protection order. Whether or not 2009 report accurately reported that the plaintiff was a victim of rape, it is clear on the plaintiff's own admissions that she has suffered significantly emotional trauma in the past. To inaccurate reporting of rape might have some relevance if the person in question had suffered no other personal trauma. However, this is not the case here. The plaintiff has herself disclosed significant other trauma, therefore no significant weight on the alleged inaccuracy the plaintiff points out in 2009 assessment. I think I've already expanded on the reasons why I had noted all this. So I had actually, because I put it in an application, in a sworn application, and I submitted a bit about my background, because I'm known by two names. So I had to build a case up of my background, but the report that these doctors wrote in 2009 had kind of indicated that I was still going through all these issues, but I wasn't. In fact, I was very stable emotionally. I was stable in every other way that you possibly can be as a professional woman. The only problem that I was having was the cyber attacks, things that were happening that I couldn't control. But I had to show the judge that what the actual report was talking about were issues that happened, as already mentioned, from 1997 to 1998. And the children of my father wasn't even in the picture in any of these things. And it was also to prove that my case was purely cyberbullying, had nothing to do with domestic violence whatsoever. So that's why this information was relevant, and it was also to prove that what the cyberbullying and everything that I had gone through that was out of my control, that everyone had put me at risk. So that's why that evidence was vital, and I had to prove that to the court. I find the statement of claim discloses no reasonable arguable cause of action against the fifth and the sixth defendant. I further find that even with an opportunity for further amendments, there would be no cause of action against these defendants. Okay, so that is what judge has written. So I'll leave it at there because this video has gone too long, but the next video I'll continue with the judgment of the actual decision. So keep watching, and yeah, so I hope you are getting the gist of the actual case now. But I will leave it at that, and I will see you in my next clip. And in the next clip, it will be the last one, and it will be just talking about what the judge actually, the decision that she had made. Yeah, so thanks for watching, and I'll see you in the next clip. Bye. If you want to refer to the actual episodes that's in this judgment, it's episode 23 is the report assessment dated 8th of July 2009, and episode 24 is the actual report that the employer, that the medical practitioner that was wrote the mental health assessment on behalf of the employer, dated 18th of November 2015. Episode 26. So episode 26, that's the assessment, the actual assessment that I had with the psychiatrist, dated 4th of February 2016. So there's a total of 5 medical practitioners basically under one umbrella. When I say one umbrella, the other practitioner, even though he did the assessment on behalf of the employer, he didn't work for the employer like under the same umbrella. So the name of his company was completely different. 5 of the medical practitioners all work under the same health, what I mean is government agencies. So they all sort of like fall under the same umbrella as a government agencies, but they've got different names. So that's why I chose the name of the company, because the legislation allows, they fall under the government agencies. So if you know how to read the laws, that's where I was coming from.